No, Marcia's gonna be here for a meeting. Yeah.
Well, we are behind, aren't we?
Yeah.
Okay, so, 14 state attorneys, including Sarah George, are opposed to the term probable cause. In page 1, subchapter 2, 162A, definitions under 2.
Maybe John
I suppose we could use the term reasonable suspicion exists. The law enforcement officer believes.
Yeah, that would be a broader term that could be used, so it would still kind of give that reason that was discussed, but could potentially broaden the scope of pre-charge diversion to include more offenses or conduct.
Well, I saw her drive into my mailbox with her vehicle. Law enforcement was called. They arrived at the scene. Based on my testimony, they had reasonable suspicion that she had committed the crime with her truck and driven into my mailbox. And they would then be able to, for diversion,
Potentially.
if they want, if they so choose. Then they found out she was driving an unlicensed vehicle, unregistered vehicle, excuse me. So anyway, Senator Rashid.
Yeah, I must have missed something because I'm not understanding why it's a problem that probable cause is in there. If the government is telling a person that they have to go to this program and the SA has discretion to say there may or may not be a charge if you don't complete the program, there has to be some threshold there for whatever fact exists.
That was the discussion with the state's attorney earlier.
Right, and so
Who saw the problem.
right, so I would see what the problem is though,
Yeah, I agree, and especially after what we heard from Judge Zone, that this already happens with the decision to send to court. This is just saying this has to happen if it's gonna be a decision not to send to court and send to pre-charge. I don't see the problem, especially given that it doesn't in any way say the prosecutor has to be the one to officially determine probable cause. It says the referring officer. Like, I don't see the problem.
Okay, I'm gonna propose that we delete probable cause and insert in thereof reasonable suspicion. Making it changing the words to fit reasonable suspicion. So that's the motion, and then we can discuss it.
I think it would really just be a replacement of the term.
Yeah, I don't know how it works.
Yeah.
Yeah. I mean, I certainly like it better than having nothing, but I'd prefer to just leave it probable.
Well, I think that part of the problem is, the problem with probable cause is it's a standard that's well versed and it indicates that something has to happen, and that's where as I understood the state's attorney's comments, they didn't want to have a finding of probable cause to pre-charge.
well, my understanding, and I'm happy to stand corrected, but my understanding is that if the information is sent to the judge will decide that probable cause exists, right? But before that, you have the cop gathering all the facts and circumstances and then sending an affidavit to the SA saying that they believe probable cause exists and they recommend charges. And then the prosecutor decides if those charges, if they'll send the information to the judge.
The cop could also send it directly to diversion.
Mm-hmm.
Right, and so my thinking though is that if the government is requiring that somebody goes into some sort of program or in this case pre-charge diversion, there has to be a basis for that. you know, I mean, is it just, I mean, will it just be a hunch? If, like, I mean,
Reasonable
well,
suspicion.
right, so
Just
more than a
standard.
hunch, but less than probable cause, so. I don't know, it just seems, at first glance, it seems strange to me that we are, that the government is telling someone to go into a program, otherwise they'll face consequences, and it's being done on a threshold that's less than probable cause.
Like, as I see it now, we're looking at pre-charge as an alternative to charges being filed, and if charges were gonna be filed, we would need probable cause. And so therefore, if the alternative is to charges being filed as pre-charge, we should also need probable cause.
Bob, do you have any strong feelings about this?
Oh, goodness, yeah. Well, here's the thing, I don't have probable cause does rise to that level. I mean, you all remember from the days of the category facts, circumstances that lead a reasonable and prudent individual to believe that a crime is or about to be committed. Reasonable suspicion, obviously, is a lower clause, but this simply says under 2, a referral of an individual. I guess if we looked at, because everyone seems to be afraid of those law enforcement officers out there because they can't make their minds up on their own. So if we were to simply put under line 14, a referring officer and prosecutor, meaning that they would at least have to touch base with the prosecutor's office, say, listen, this is what I've got. There's no charges. I want to give Nada the option to take this referral and go to this without none of this taking place. And if he chooses not to, obviously that's obviously his decision, but then we can continue the investigation as Ben has said, and then we'll establish that, probable cause level that we need to press a criminal charge, but we're not doing that with this referral.
I think part of, I hear what you're saying. I think part of the issue from the earlier conversation, from what I could gather, was that some law enforcement are sending cases to diversion without reaching out to the SA, and the SA is just has a level of trust with that agency to use their own discretion.
I'm not familiar with that because in Franklin, we never had that option. We could
Did you
certainly
testify?
recommend diversion when we contact the prosecutor.
We
We never
do
had that
Chittenden County.
I
authority.
think it's
You do in Chittenden
different.
County?
Yeah, Chittenden County does have a policy of allowing officers to directly refer,
It may have changed. I've been at
Yeah.
it for like 6 years here.
which I don't want to stop that. I just want to make sure that anyone who's being referred to the alternative of a charge meets the same threshold as if they were to be charged.
Well, anyways, getting back to the question at hand, was it 14 state attorneys say that they don't like the probable cause, and that I'm leaning towards saying reasonable suspicion will meet my threshold level.
So that's 2-2.
We need Senator Baruth.
Depend on Senator Baruth.
I feel like, so in an instance where probable cause isn't met and someone says, go to pre-charge, or like, maybe we have the evidence to charge you with a crime, maybe we don't. That also creates a lack of accountability in that sense. So someone is then told you have to go to pre-charge, and if you don't, maybe we can charge you with a crime. Like, I think it protects on both ends to have the threshold be the same if we're talking about alternatives to charges.
But if you're gonna go through all that, all the paperwork involved, so on and so forth, the investigation, the citations, the affidavits, whatever else, I'm just gonna send it over to court. Say, there you go, SA's office, there you go, charge them all. I'm gonna
I
refer
think
them
you
to.
get fewer.
You're gonna get few of them, yes.
But if you don't reach probable cause, you can still make a community referral. You can still make the referral to a community justice center. You just don't do it
I think
under
it'd be
pre-charge.
tendency that you've already found probable cause, so why not go to the court?
And I'm gonna charge them, send them over.
Anyway, we need 3 votes to do something.
Right.
So, going over to page 3, what the hell does the Attorney General may require local financial contribution? Does that mean the Attorney General can require the town to contribute, or does it mean that the individual would contribute?
Well, this is a holdover from existing law and the diversion statute.
Well, it's underlined, that's right.
Well, just because it was moved, the location was moved, but it's current law, for the diversion program in general, which is now the post-charge program under this bill. My understanding is that this really doesn't occur currently, so I don't know what it would actually look like.
Willa, can you,
Certainly, the Farrell Attorney General's office, as Ben says, this is current law, we don't require local contributions, and should the committee choose to strike it, that would be fine.
I would propose we strike this section since it's currently not done. And I would hate to lose a diversion program because the town of Bennington decided it didn't want to support it anymore. If that's who we're talking about.
I think the way I read this is that our office, when awarding a grant, could say to a grant recipient, and you have to provide a 10% match, however you choose.
Bank
to
sale,
fund it.
I mean, bake sale.
Right,
Could be.
but we don't do that.
I think we can take this out safely.
So both in the current diversion statute and the
Yeah.
new location as well.
Yeah, I don't, if they're not doing it, why do it? I mean, why require it?
I agree.
And then on page, I'm just going by my notes now. The juvenile, on line 4, page 7, the juvenile pre-charge diversion policy required. Is that the same issue as the other policy issue?
Yeah, so the policy requirements for both adult and juvenile are the same. in both
But I
portions.
had that listed as wrong, and we were gonna strike that.
Which portion? you-
Well, starting on line 12, 2, juvenile pre-charge diversion policy contents. I have that written as wrong, I don't know how far the wrong goes.
So I have a note in mind to strike line 15 and 16 and replace it with language that all juveniles should presumptively have diversion available to them.
Right, but B also,
Well, so this is just what's included in the policy. So this gives the state's attorneys the discretion to decide what are the criteria to determine whether a child or youth is eligible to participate.
so are we gonna have policies for juveniles?
Yes.
And what are the consequences of not adopting a policy for juveniles?
It's the same. Funding from the AGO would be, they would not be
I
eligible
can't
for
support
that.
that.
So I feel pretty strongly that if pretrial work is being done, there should be a transparent policy. I don't see it as punishing the CJC. They can still access other money. They can still access community money. But if the AGO is supporting pretrial work, I think there has to be a written transparent policy.
Okay, I don't wanna penalize, the way I read it, then that particular, if Essex County doesn't have a policy, they wouldn't receive funding from Barge.
That's not my understanding. My understanding is that if Essex County doesn't have a policy, they don't receive pretrial funding. And the way I see it is if they don't have a policy, they shouldn't be doing pretrial work.
So the way the law works is that there are two sort of hooks, if you will, when it comes to policy adoption. One is that if they don't adopt the policy, then the Attorney General's financial support is restricted or is prohibited. They also wouldn't be able to accept referrals. So those are the two things that are required for the policy adoption. But it does not prohibit funding from other sources outside of the Attorney General's office.
Yeah.
So they can still do Barge, they can still do community referrals, they can still take money from the municipalities. It's just restricted to that pretrial funding and referral.
But I don't agree with that.
Question?
I agree with line 15 and 16 being struck. Senator,
Just for my clarifications, what is considered a juvenile in the state of Vermont? Keep moving to goalposts here.
The
Is it
child-
16, 18? What
A
is it?
child or youth as defined in Title 33, and it's a very complicated definition. But basically, a child, I believe, would be, well, they're both attached to raise the age. But I want to say it's between 10 and 18 currently.
currently it's 10 and 18. In 2025, July 1, it'll be 19.
That's just, that's good clarification from that.
Yeah,
We keep moving.
it is a moving target.
Well,
Thank
we
you.
move it backwards. I was trying to explain that to Senator Ingles when we voted against that.
Yes, that was a confusing vote.
That he was actually voting to have raised the age start July 1 of this year. Anyway, Marshal Paul has arrived, so I'm gonna ask him to comment on at 6:45. We've already done a lot of dislikes and likes about this bill.
Well, my testimony will be brief. We support this bill. We think that pre-charge diversion is really important. I've worked in counties that have pre-charge diversion and counties that don't, and the difference is really tremendous. The number of cases that come in is much greater in counties that don't have pre-charge diversion, and there's a lot of counties that really use pre-charge diversion to great effect. There's also really tremendous disparity between counties. I mean, there are counties where something like more than 50% of eligible misdemeanors are going to pre-charge diversion. In other counties where those numbers are much, much lower. And so one of the things that we see in this bill as a real positive is that this bill, we think, will encourage more uniformity across the state, more predictability across the state. And by requiring CJCs to have policies, more transparency so that everybody knows what the policy is. Because it really does vary dramatically county to county. So we're very much in support of this bill. We do have to say one thing, which is that in the House, both I testified about this bill and testified in support of it. My boss, Matt, also testified about this bill, and he testified specifically to the money issues because this bill includes a provision that's not existed before, which would provide that anyone who's getting pre-charge diversion has the ability to consult with a public defender. What Matt told the committee was that we could do that, and we could even do that fairly cheaply, but we would need the money to do that because we are already in a hole. And my understanding is that at this point, that money is not part of the budget, not part of has not been
You are
appropriated.
correct, because all we're doing is filling your hole.
Yep, so,
I mean, our proposal on the Defender General's portion of the budget is to fill those holes that are already existing under contracts that you've already
understood.
signed, so there's no new money.
And that's where, so the provisions in this, like, for example, on page 13, that says diversion candidates shall be informed of their right to assistance and access to private counsel or the public defenders at all stages of the diversion process. We would like to support that, but we can't without the money, because frankly, we are at the very edge of being able to maintain the services we provide now. And without funding, we can't provide more services.
Senator Jean and then Senator Bowers.
Thank you. I'm still grappling with the probable cause piece on page 1. And can you share your thoughts on that? Why should it be there, or why shouldn't it be there, or are you neutral to that?
I think that it should be there, and the reason is that this is anecdotal because I only know information about a few counties, but in my conversations, there's a lot of times when prosecutors file charges where probable cause is not found. And I don't think anybody should be being sent to diversion for charges that wouldn't even make it to the bench in court. So I think that's my short answer as to why I think the finding of probable cause is an important piece.
Thank you.
My question, do you have any sense of how much additional money would be needed for this?
Yes. Matt did a pretty conservative analysis based on assuming that this bill would cause an increase in pre-charge diversion of approximately 20%, and that these consultations would be approximately, we use a weighted caseload system to determine our caseload. So he assumed that these would be approximately 1/3 of the amount of time that somebody would spend on a misdemeanor, because we have caseload recommendations from the NAC for how many cases a public offender should have, and they're based on misdemeanor, felony, child protection, but they don't have a category for this type of case. So we just made some assumptions that it's about 1/3 of a misdemeanor, and that only about 20% of people who were given the opportunity to call a public offender actually would. And based on that, what Matt had envisioned was having 3 contracts, one in the Northeast Kingdom, one in the Northwest, and one to cover the southern part of the state. And that total would cost between $150,000 and $200,000.
So it's a relatively small amount. And would it be possible, given that this likely would sort of roll out over time and it wouldn't be July 1st, all of a sudden you need this increase, would it be possible to potentially address it in the budget adjustment?
I don't know about that. Typically our office has not gone through budget adjustment. We've made it, I think, 24 years coming in under budget without going through budget adjustment. So I couldn't really tell you what the likelihood of us being able to get that money during budget adjustment would be. I will say this though, is right now we do have pre-charge diversion, and it does not involve, there is no right to contact a lawyer for pre-charge diversion. In fact, as public defenders, we don't even find out when our clients get pre-charge diversion because it all happens pre-charge, and we are assigned to the case at the point of charging. So I don't think that it's would be the end of the world to remove that provision for now, and if money becomes available in the future, to add that in. I was asked in the House to describe, what would the role of a lawyer consulting with somebody about pre-charge diversion be? And it is pretty minimal. I mean, we wouldn't be serving as their ongoing case representative lawyer. We would be making, basically explaining what pre-charge diversion is, explaining the pros and cons of that compared to the pros and cons of going into court, because it's a voluntary thing, and if people don't want to do it, they don't have to do it. And then giving them advice as to whether or not it's probably in their interests to take diversion or not take diversion. And there's plenty of reasons why you might not want to take diversion. I mean, the most obvious one is if you're not guilty, if you didn't do what they are charging you with doing, you probably shouldn't go take diversion, because the first thing you have to do in diversion is take accountability for what you did. So there's plenty of good reasons, and those are the kinds of things we would counsel people on. But at the same time, it's not as if the system doesn't function right now without us. And so as much as we would like to be there to consult with people, we can't do that without the resources.
So,
So
go ahead.
I guess my question, given that we don't do this now and the monetary amount required is based on a bunch of assumptions, is if it would be the worst thing in the world to leave it and then see at budget adjustment, how much did it cost, and pay that back? Because it might be 150, it might turn out that people don't actually ask for it, and it's 25, so I guess I'm wondering sort of the flip to that.
That's something that I'm definitely not allowed to take a position on.
Okay.
However, I can let Matt Valerio know. I can let Matt Valerio know about that, and he'll.
Okay.
Let me simplify this. Ben, is there a joint fiscal analysis of this bill? And is there an appropriation with the bill, and did the bill ever go to the Appropriations Committee in the House?
There is a fiscal note, and it did go to House Appropriations. But it was just regarding the 2 positions that were in the bill. Initially, the one for the Attorney General's office and one for the Department of State's Attorneys. The state's attorneys role was struck, the Attorney General's role was kept in.
So there is no position for the state's attorney.
Correct.
Can we get a copy of the fiscal note?
Versions past that.
Oh, did that?
Yeah, I think they're both in the versions past, sorry. Yeah, I think they're both of them.
Did they fund it?
No, so that's what happened. They kept it in, but it was contingent on.
One more damn time, this House of Representatives has been irresponsible in budgeting and left it to the governor of the Senate to try to budget things. And I am furious that this year has seen H-880, which is in here, funding all of the important roles in the criminal justice system with a corporate tax that the governor would quickly veto and the Senate wouldn't pass. And they knew that, and this is a friggin' game, and I'm tired of the game. So that's public, that's a rant, and rant's over, but not your fault, Marshall, not your fault, Tim, not your fault, Willa. It is just frustrating to the nth degree that the House passes bills without putting money in them or taking the money out and saying, this section will be applicable if money is available. And that's an alternative that we could use. If the money's available, this section applies, if not. That's what we did in the appropriations amendment on F-155.
So it's contingent on funding.
Contingent on funding.
And to be clear, we would be fine with that. This is work we would like to be doing.
Mhm.
Like, we're not
But I don't
saying
think we
this
should
because
put
we
it
don't
in
want to be
there.
doing the work.
Requiring you to do
Oh,
the work
absolutely.
without
That's-
the money. So the easiest way to satisfy everybody is to say contingent on appropriation.
Yeah, I mean, I'm certainly,
I have never seen a year with more irresponsible budgeting than this one.
So, Senator Cruz, just for clarification, add language.
Add language for both positions, if they're both in there,
then the
as well as for the position for the Defender General to do anything. So there'd be three different areas.
And ours, to be clear, wouldn't be a position. It would just be, because we would do it by contract.
And so these sections are contingent upon funding and the same language we used in S-195.
yeah, I guess given that it's not work that's currently being done, it seems like there's a big question mark about how much it actually costs. And so
Well,
that's
that's why I don't have the joint fiscal analysis. Can you get that for the next meeting?
Yes.
which is why, and I know you can't take a position on this, which is why it seems to me, given that the sort of estimated cost isn't huge, 150 to 200,000, that's why it sort of makes sense to me to do it and then look in the budget adjustment, what did this actually cost?
Well, but I can tell you right now what Jane would say.
Yes.
She's already got in one times like $40 million more than is available in requests. In standard budget, she's already got about 300 million more than is available. Which includes paid fees and leave and things like that, which probably aren't gonna happen, but there are much more requests for funding. And we don't know if FY '26 is gonna be tighter than '25. And so we're trying not to start new programs unless we, see funding for it. And that's why I'm troubled by the House not even making an attempt to fund these positions that they're, it's very frustrating for me as just a member of the Appropriations Committee to see this continued effort to build budgets that don't have a basis in funding. And so even if it's a small amount, it's still new base money when people in domestic violence, because they just walked in, are getting a 0% increase and in some cases being decreased and trying to live with that. They have the same budget pressures for payroll, like health insurance, et cetera, that the state does, but they're getting 0%. The designated agencies are getting 0% under the governor's budget. So that's.
Oh, I share your frustration. And I guess when I look at something like this, and Marshall, certainly correct me if I'm wrong, if we increase pre-charge and we support people to understand and potentially take pre-charge, we decrease the charged individuals, which may decrease your caseload in another space, which may end up balancing it out. And we may get to budget adjustment and say, oh, actually this sort of balances out, or it's $20,000. Whereas just not doing it unless we have the money up front sort of keeps the status quo. Like, I see this as a place that could ultimately result in cost savings.
But
That might be true in normal times, but in normal times, our public defenders are carrying caseloads of 60 to 80 cases. And right now, we're carrying caseloads on average between 175 and 225 cases. And so even if this turned out to, like, as you said, not be as impactful, we're still underwater. It just, that changes how much we're underwater, but we're still underwater right now.
No, I hear that, and I'm trying to think of every possible avenue we can make towards getting you less underwater so that we get to more normal times, and I sort of see this as a potential.
Oh, and me as well. I mean, I think that this could be, in a lot of ways, very beneficial to reducing the backlog, because if you look at the court backlog right now, it is going down, but it's going down at this trickle of a rate that is so slow. I mean, it's, you know, it's like making your minimum credit card payment and you're gonna pay off your credit card in 50 years doing it that way. Like, that's sort of the rate at which the backlog is decreasing right now. And so the way we see this bill as being potentially very helpful is by, you know, that the reason that it's decreasing is not because we're not moving cases. Cases are moving, but cases are also coming in at a very fast rate. And this has the potential to sort of shrink that pipe of incoming cases and allow us to address some of those backlog cases.
turn ourselves back to the Columbia University study that Dr. Black on the raise the age when we went to 18-year-olds. And the number of cases that were diverted as a result of raise the age was certainly a cost savings.
Mm-hmm.
And there's no reason to expect that the 19-year-old won't be a cost savings to everyone except the diversion programs. So I that's where it's hard to predict money-wise until the policy actually takes place. And you may be absolutely right that it would actually save money. And the only place we've been able to find where we can actually prove we're saving money is out-of-state beds. Because there's a certain price to each bed, and you can, if you don't fill it, then you can take that money and use it something else. So, I think that's where the problem comes in, proving that. But there had to be savings in corrections when the 18-year-olds moved over to DCF. But we didn't reflect those savings in the budget. There was nothing put aside, and DOC didn't, you know.
Yeah, I think we have to get better at tracking those savings and making sure that they, you know, the DOC savings go to DCF,
Right.
yeah.
But I don't even know if DCF had an increase or significance. I mean, their major problem and hard to prove anything is because they didn't have a place for it. Hard to place. But I think that's it for Marshall.
All right, thank you very much.
So Ben, I don't know, I think we've given you some instructions for a possible rewrite in the draft, and I know you work with Senator Bowski on other areas, so. When are we scheduled to take this up again, Beth?
Friday. I have this for, I think I have about 45 minutes of markup scheduled at 10:45 on Friday.
Yeah, can you stop at 10:45 Friday?
Yes.
Okay. Are there other areas that are obvious to people?
So the only other thing that came up for me, and Ben, I apologize because I didn't bring this up yesterday, was the redesignation from Title 24 to Title 28.
That's,
That's
That
the
is
last-
page 59, section 10, starts on line 12. It is very short.
Yeah.
And this is coming from my own sort of long game hope that we eventually have a title that pertains to restorative justice as a whole, and that restorative justice apply to more than just corrections. And so I have concern moving it into the correction title, because that sort of precludes for me, like, moving in a more global, broad reaching direction. I don't know that Title 24 is the right place for it, but I also I'm not super compelled that Title 28 is the right place for it. So I'm hesitant about the redesignation at this point in time.
It's completely a policy decision, you know, as,
I don't have a problem taking that out, but DOC wanted it.
yeah, and I think Jared, Dubnik's testimony is sort of in line with what you're expressing, is that at one point maybe, but there are broader issues.
Did we make a decision on section 8? I have a note that the Attorney General would like that struck.
Not that I'm aware of, I do know that that was, you know, testimony from the Attorney General, to strike that section. What it does is essentially just provides a bridge between now and when, the program goes into effect to do that. I think that from a policy perspective is up to you, but I do know that the community justice centers, I think wanted some assurance that there was continued funding during that bridge period. But ultimately it's a policy decision for the committee.
I will add, I did speak to a couple of the community justice centers that we had in, and they did really want to keep this language. It's kind of belts and suspenders, just gave them some comfort, that they're protected while we figure some of these details out. So I would advocate that it stay.
Senator Sheen.
My question isn't for section 8,
Okay.
so unless I can wait.
Is the committee okay with leaving section 8 in or taking it out? Well, do you want to make another comment about section 8?
I'd be happy just to repeat, my request that it be removed. And I think when Tim testified earlier, his statement that one state's attorney is hesitant to use pre-charge diversion because he wouldn't want to penalize the post-charge diversion provider in that county speaks to the challenge of having pre and post-charge services funded in different entities. And I think the more this body can do to convey the message of getting to one administrative function at least, particularly in smaller counties, would be helpful to further, a more logical, coherent system in communities. I do think Chittenden County is it is larger and there are, it's a big part of our state. So the way the bill is written now, it would require us to offer funding to every existing pre-charge provider, regardless of how many pre-charge, referrals or what policy exists or doesn't exist. And I think that would be burdensome.
Senator Sheen.
So actually this is on section 8. So is the general underlying goal to move to a more streamlined process with just one CJC in each county to work with the Attorney General's office, but the concern is that this is requiring the AG fund all the CJCs, and so it's kind of just creating a roadblock to that eventual consolidation that you'd like to see?
Yes.
Gotcha. Thank you.
It's an easier vote for me than Chittenden County was before. I only have one in my county.
But my understanding is the language in 8 reads that the AG may fund more, not that they shall.
It is shall currently, but that could be an option, is to make it discretionary.
I would be more comfortable with that than deleting the whole section, just as a way of sort of acknowledging that Chittenden County is in some ways a unique animal.
Okay, well, change it to May, I can put that.
Does that?
Yes,
Okay.
that would be helpful.
Okay.
Yes, thank you.
I'm good.
Okay, we're gonna take up coercion. controlling behavior.
I'll continue to work with the officer.
Perfect. Thank you.
Okay, so we will take this up again Friday.
And, for the committee as well, if you continue to have other questions, just reach out to me, I'm happy to answer them.
Okay, thanks. Thanks.
Alright, I can trade out files.
Well, Michelle will be here shortly. I want to trade files.
Yep. and
Keeping 6:45 this time?
Sounds good. There you go.
Thank you.
Figured I'd give you that information so you didn't think it got lost.
Yeah,
I have it.
that's happened a couple of times. No worries. And Stefovsky. And I just messaged Michelle
I
that we're
got
running.
two of these. Does anybody need one?
Oh, you got two of them?
Is this?
One.
Yeah, they're both 1058.
Yep. Okay, sounds good. I usually put an extra, I must just put the extra in yours. Nice.
Oh. Right,
That draft 1.1.
this is this bill. Yes.
I think this was based on Connecticut.
Yeah, I reacquainted myself very quickly with it.
Which was our request to Michelle.
Yes.
Here she comes.
We know your footsteps.
We do.
Good morning. Welcome. So, the committee is taking up H27, which has to do with coercive and controlling behavior. And we have a strike that Michelle has drafted, and I believe much of it is based upon Connecticut's law regarding coercive and controlling behavior. So, Michelle, I'll let you walk us through the
Sure.
new draft.
So for the record,
Draft 1.1.
1.1, yep. For the record, Michelle Childs, Office of Legislative Counsel, and as the chair mentioned, it's draft 1.1 drafted April 11th. So just as I know you're dealing with a lot of issues, so just as a refresher, we're just talking about civil abuse protection orders. So this does not affect the criminal law with regard to domestic assaults, only for the purpose, the only thing that this does is amend the definition of abuse for purposes of obtaining a civil restraining order. So if you look at section 1 and you have your definition of abuse in subdivision A1, and the new language starts on page 2. And so it's adding within the definition of abuse, coercive controlling behavior between family or household members, which is that's only who can apply for orders under this chapter. And then you see in subdivision A2, you have the definition of coercive controlling behavior. And as Senator Sears mentioned, it's modeled after what you saw for Connecticut. Connecticut is a newer law, but it also incorporates some of the language from Maine, which you also looked at, which has been around for much longer. So you see, starting on line 3, coercive controlling behavior is a pattern of behavior that in purpose or effect unreasonably interferes with a person's free will and personal liberty. You'll see, starting on line 5, coercive controlling behavior includes unreasonably, and so that's a key word there, engaging in any of the following, and then you have some of the examples. So first one is isolating the family or household member from friends, relatives, or other sources of support, depriving the family or household member of basic necessities. C is controlling, regulating, or monitoring the movements, communications, daily behavior, finances, economic resources, or access to services. D is compelling the family or household member by force, threat, or intimidation. Oh, I don't know why they didn't give agents. I'm going to strike that, but not limited to, if we don't use that. On line 14, threats based on actual or suspected immigration status. To engage in conduct in which the family or household member has a right to abstain or abstain from conduct that such family or household member has a right to pursue. And then finally, committing or threatening, although maybe there's one more, to commit cruelty to animals that intimidates the family. And sorry, there's one more on top of page 3, for sex acts or threats of a sexual nature. Sorry, I don't know why I didn't get those other ones when I picked those up. So those are the changes. So it's basically the Connecticut language. And I think, as I had mentioned to you before, that's a newer law, but incorporates part of some aspects of the Maine law, which I talked to you about some of the cases that were considered under Maine. Mm-hmm.
So unreasonably, that is sort of the way we trigger in here that one would use the reasonable person standard.
Right. And so I think, in the version that passed the House, and I think one of the sticking points that you had discussed was around, a parent making decisions for their child around either whether controlling their finances or saying, you can't go to this party on Saturday night because of certain reasons. And so we did run it by Judge Zone. He felt comfortable as though that by the inclusion of unreasonably kind of was taking the place of what we have in the House proposal around that exception around for parents or guardians exercising their constitutional rights for care, custody, and control with regard to parenting decisions for their child. And so he was satisfied that this gives the court enough guidance to be able to ascertain on a case-by-case basis, considering the factual circumstances, and to be able to make a decision as to whether or not the conduct, like if you had a minor child. So this does not exempt minor children, and the court would then be making the decision about whether or not it's reasonable.
Can I, just on section F,
Mm-hmm.
I'm assuming that the actual use of such acts would be criminal, and that's why.
Of course.
So that's why it's not, somebody asked, why isn't the actual release of sexual images, because that's criminal.
Correct. I mean, again, this is, I think you could probably say, placing another person in fear of imminent serious physical harm, might qualify under the existing law. But again, here, it doesn't mean that because something's here as the basis for obtaining a protection order, doesn't mean that it also can't potentially, depending on the conduct, be criminally prosecuted. So if you think about, let's just think in terms of how it works now, if a husband assaults their wife, physically assaults them, she can go and she can apply for a protection order under Title 15 currently, but there could also be a concurrent case in the criminal court. And, and I'm sure y'all have heard witnesses on this issue for a number of years, is there's a lot of reasons why there might be one and not the other. And they are independent of one another. And it could be that there's a criminal case and the survivor does not want to file for a protection order for various reasons. And, or there could be a protection order and maybe it meets the technical definition under domestic assault under Title 13. But perhaps the survivor doesn't want the state pursuing a criminal charge because, so both are options depending on the circumstances. But when you're talking specifically about coercive controlling behavior, that is not an option under the domestic assault
Senator
chapter.
Cruz and then Senator Bowski.
So I like this draft much better than the last. I still, on page 2, even understanding that unreasonably is the frame through which we're viewing it, C still seems to me to grade into a lot of areas where, different, and of course it would be a judge deciding, but I'm wondering, since we have below on 16 through 19, we cover preventing somebody from engaging in the conduct to which they have a right or abstaining from conduct to which they have a right. I think we cover what's in C with those without needing to articulate whether somebody is regulating or monitoring finances, communications, etc., because children and minors are included here. So I'm wondering, could we remove C and still have everything in it covered by what's in D?
I think that C does encompass some activities that D would not necessarily, which is, so if you look at D, compelling the family or household member by force, threat, or intimidation.
Yeah.
And then you have and so.
But what I'm wondering is if a parent, let's say, is monitoring the child's phone and their bank account and their car, which a parent might be doing. It seems like then the question for the judge is, does the parent have the right to do that? And so that leads you to that more general language.
I wouldn't say that. What you always want to do when you're looking at these subdivisions, so let's just say the controlling the finances as one issue, right? So controlling the finances, then you have to go back up to the lead-in language for 2 and say, in that circumstances around controlling that child's finances, does it unreasonably interfere with that child's free will and personal liberty? And they're gonna look at the factual circumstances in terms of what is the age of the child, right?
Yep.
So it might not be, it could be a minor, but it could also be a college student, right? So who is not a minor? What's the source of the funding? Is it a shared bank account? Like, I know I have a share, my daughter, we have access to the same account. So do I have, so it would be in the context of that. And then the court should be looking at that, the individual circumstances, whether it's unreasonable. I mean, you're certainly free from a policy perspective if C makes you too uncomfortable to do that. But
I just think for C, there's an app that does all of this. There are different apps that would do all of these things. That would, you can track somebody's movements with an Apple tag. You can monitor their finances, and you can monitor this, that, and the other thing. I would never do that with my kids, but I think there are parents who are viewing those as parental options. That's from the beginning. That's been the piece that's made me uncomfortable.
Shame and then Senator Bowski. I'm sorry to keep putting you last, but I saw your hand.
It's okay.
So substantial emotional distress is no longer in there.
no, that's all gone.
So it's just, if it's unreasonable and the judge would make that or the jury would make the determination if a certain set of actions, is unreasonable.
Yeah, reading the House version, it was coercive controlling behavior means a pattern of conduct that recklessly causes or has the effect of causing a reasonable person to fear to any of these things, and then went on to.
I don't know how this is better, for your concerns, Senator Baruth. I mean, it's, you know, it doesn't, aside from free will and the personal liberty. Let me figure out how to phrase this. So, you know, we previously had the injury, which would have been substantial emotional distress, and here it's an unreasonable interference with free will and personal liberty. So what is unreasonable for one family could potentially be reasonable for another.
That's what I'm saying. So in other words, C seems to me to get into more mundane things in a family's operation, whereas the other ones are threats, preventing them from exercising their rights, cruelty to animals, you know, threatening to deport them or out them sexually. Whereas in C, you're talking about things that there are apps out there designed to do those things that millions of people are using, which is to monitor the family's finances and communications. Just to take those two, there are, you know, I can't even count the number of parental apps out there that do that. So it just seems odd that we would be making it seem as though those could wind up being matter for a relief from abuse. But anyway.
Senator Bowles.
I think the fact that millions of people use it would probably be weighed in the determination of whether or not it was reasonable or unreasonable.
Mm-hmm.
And I do not feel comfortable removing this. This to me is the language that is sort of getting to what happens before threats and physical violence. For example, if I am sharing a bank account with my child, and I'd like to believe I'm relatively reasonable on many things, I would view that as perfectly reasonable. Whereas if I'm a parent and my child's at college and I say, well, if you dye your hair pink, I'm no longer going to give you money for food, that is unreasonable. It is an unreasonable control of that child's money.
I would say that's your opinion. I mean, there are plenty of parents out there who would say, if you're using my money, you follow my rules. And
I think I heard that once, was if you're living under my roof.
If you're living under my roof, okay, exactly, yeah.
You will do such and such and such.
right.
And you won't do such and such and such.
I think you want to keep in
Those were
mind whether you're
choices that were
talking about
given. I
a
think that
minor.
was controlling behavior.
Right,
but
but
I'm
we've mixed them here.
not sure.
Right, but I mean, in terms of,
But if
The
we
judge
pass the
still
bill
has
as
to
is,
find, right,
That it's unreasonable.
that it's unreasonable.
Yes.
but I'm just wondering why, if, I don't know, you could put lots of other behaviors in there and say, like, walking the dog. Doesn't seem like it would be a problem, but if it's unreasonable, they do it.
You'll get up at 3 o'clock in the
Right.
morning to walk the dog
So
every morning.
I'm just saying the behavior that's described here is not itself unreasonable or looks like we should be penalizing it or criminalizing it in any way. It's, then we're thrown back to, is it unreasonable? But the other ones, you don't really have to use the unreasonable standard, because depriving somebody of basic necessities or threatening them or forced sex acts, those are things that rise to a level where we should just be prohibiting them. But monitoring your family's finances, you know.
Having worked with abuse survivors, I've seen these used as tools of coerce and controlling, and I think that that's why they have to play together with, is it unreasonable? And maybe it is adding back in language around like creating undue stress or fear. But these are the sort of day-to-day ways in which abusive individuals control and segregate out from normal, reasonable day-to-day life so that they can control a person. So I think this is actually really critical that it be here, but I'm really open to thinking about how we further look at unreasonable and damaging or something else in that lead in language.
And for me, part of the problem is that we eliminated the carve out in the House bill for minors.
Yes.
And so now this includes everybody. So just to go back to C, monitoring daily behavior. What parent is not doing that? That's what being a parent is. You monitor your child's daily behavior. So I don't understand why that language would be in there for minors. Like, I'm at a loss. So
Well, if you qualified that to causes or has the effect of causing a reasonable person to suffer substantial distress, I don't think I have to use emotional, suffers substantial distress, which are words from the House bill. I think you're now qualifying this.
well,
Causes that person excessive.
back to our earlier discussion, if you have a child and you say to them, I'm monitoring your finances, you can't have any more money and you can't use the phone, they may burst into tears. And that's, to me, evidence that they are substantially emotionally distressed. But again, that's, you know, a quote unquote normal thing in a house with,
Would you advocate for taking C out?
that's what I'm advocating.
I do not support that.
Or carving out, minors, you know, and eliminating the parental question. But
Sarah, did you want to make a
I would
comment?
love to speak to that
Yeah.
when the committee is ready.
Well, I think we're ready. So we come down to C as being the problem child.
Sarah Robinson, Deputy Director at the Vermont Network Against Domestic and Sexual Violence. Thank you so much for all your work on this bill. Largely, we're very supportive. We appreciate the change to the Connecticut statute. We think it's strong. Appreciated working with Judge Zone, who I would say, I'm certainly not speaking for him, but concurred and thought that it provided all the tools for all the kinds of relationships that come into these types of relief from abuse proceedings, including parent-child relationships, that the language in the Connecticut statute was going to be sufficient to determine the reasonableness or unreasonableness of those requests. One of the things that I did once I heard the committee wanted to move to the Connecticut language is reach out to my colleague, Liza Andrews, who's the Director of Policy at the Connecticut Coalition Against Domestic Violence. And I brought up with her this exact question about parent-child relationships. And I would just like to read the response that I received from her. She said, as they were working on the bill, judges were of the opinion that if a child were to come in and request a protection order because of their parents were tracking their phone or not giving them money, the judges would not consider such actions unreasonable based on the parent-child relationships. We have heard no issues related to requests for reasonable parenting behavior or any information that any such requests have even been made to the courts. So I just want to clarify that I think that we have at least some evidence from another state that this kind of construct for the statute sufficiently keeps cases that are inappropriate for this kind of protection out of the system, or they're quickly determined by a judge to not be reasonable grounds. And I think that can give the committee some confidence that this construct can be useful. I would have concern about removing subsection C completely, because I do think that, especially when you think about that in the context of many other kinds of relationships for which people are seeking protection, especially intimate partner relationships, you know, those protections are very important. I think about the opportunity for an intimate partner to seek a loan, to have access to their credit, all of the things that might fall under essentially financial abuse are encompassed there in subsection C.
And to be clear, I'm not disputing
Agreed.
adult relationships and adult rights. I'm just saying that when you take this language and you put it in the context of the parent-child relationship, it draws in many of the things that parents normally do, and then it throws each case to the reasonable or unreasonable standard, whereas the other elements of the bill are dramatic in and of themselves.
And I would offer, I completely hear that feedback. I would offer, to,
Is this in the Connecticut bill?
yes,
The C,
yes,
and that's their language?
yes.
Because it reminds me of what was in the House bill.
My guess is that it has all been influenced by the model statute that was in the House bill.
I see.
So I would offer a few things. One is, I do think that what you get in C and in some of the other subdivisions there is just some plain language that's going to be really helpful for plaintiffs. So I always think it's worth remembering that most of the people that are seeking these orders are actually reading the statute to determine whether they may be eligible for the relief, and are usually unrepresented. And language, which I think is important, but that says like, engaging in conduct from which a family or household member has a right to abstain. It's kind of hard for just a lay person to figure out what is the behavior that I have a right to abstain or engage in. But the examples that are given in the subsections above do help provide, I think, just some concrete examples to plaintiffs and to defendants who are walking through the process.
Under the house.
So
That's under.
looking at C and its applicability to, say, a 16-year-old, and I know you're not a lawyer, so Michelle, feel free to weigh in if no, I don't think you're a lawyer.
I am not.
I was like, maybe you also have a law degree that I don't know about. So the 16-year-old lives in a home. There is a step parent that also lives in that home. They are a household member. That step parent is abusive and has put a air tag on that 16-year-old's car and is constantly, oh, I know where you are. I know what's happening here. And is using that behavior. If we were to eliminate either C or say this only applies to adults, would that behavior be ground for that 16-year-old to seek a relief from abuse order?
I mean, whether it could fall under infringing on someone's ability to engage in conduct from which a family or household member has a right to pursue, I mean, I think that would be up to the court to determine. But I do think that you would run the risk of narrowing the ground.
Of saying that it's okay for that stepdad to stalk in that way, to electronically stalk that 16-year-old.
It would be for the court to determine, I think.
Senator Shane.
If we were to keep all the language the same, but add on line 4, interferes with a person's free will and personal liberty and causes substantial emotional distress. Do you have an opinion on adding that? Would that make it better, worse, or are you neutral?
And causes substantial emotional distress.
Yes.
I mean, I think I would want to think about that a little bit. Substantial emotional distress is obviously in the House passed version of the bill. I feel like I had heard some, I think, very thoughtful discussion here in the committee about what is substantial emotional distress to one person versus another person. I think it would, my guess is we'd be relatively neutral on that change.
Senator Bruce.
If I might, Mr. Chair, I realize we're running up on time. This is an important bill. So I would be fine with straw voting this change because I plan to vote for the bill. So if I'm in the minority on that, that's fine, and we'll move to a vote.
I think I'm satisfied with C because of the language on line 3, beginning on line 3 of page 2. That's a pattern of behavior in purpose or effect unreasonably interferes. And then goes on to include unreasonably engaging any of the following stuff. It has to be found to be unreasonable.
Yeah.
So for that reason, I'm supportive of C, but we can do a straw poll.
I am supportive of keeping C.
I'm not supportive of the way that it is right now, C, simply because we eliminated the under the age of 18 construct to C. That's my concern with it.
Senator Bruce.
And I've made my,
So it's all up to Senator Sheen.
I'm fine with keeping it.
fine with
Keeping it in.
keeping it.
Yes.
Okay.
So it's 3-2 to keep the C in.
And I will move the bill favorably.
and Senator Baruch has moved that we report favorably as H 27, with the wrong bill number, H 27 favorably as amended in draft point 1.1, which unfortunately is, I think, a huge improvement over the House version.
Yeah.
So is there any further discussion from anyone?
Sure, can I add something, just that might
You
make
may.
people feel a little comfortable? I had mentioned it before when we talked about this, but I just wanted to remind you about, so the reason why the language that was in the House was around the constitutionally protected care and control and custody, and I just wanted to remind you of that, is that's always gonna be there, right? And so the cases that we were talking about before were with respect to grandparent visitation, where grandparents were suing because the parents were not providing visitation to the grandparents. And the Supreme Court has said, you know, it's not for the state to step in, and as long as it's a fit parent making those parenting decisions, it's not for the state to step in and substitute the state's, you know, values around that and say, and force that parent to allow that child to visit the grandparents. And they recognize the constitutional right for a person, as long as they're essentially a fit parent, to be making those decisions. And so just remember, you always have, you know, that's always a guidepost here, right? Is that it's not that the state to be stepping in and saying, well, I would do it this way.
Yeah.
Matt, did you have any comment on this?
Not one comment.
I didn't think so.
So does this still allow, say, a 15 or 16-year-old to go into a court of law and get a restraining order against their parents?
Yes.
Well, only if it's unreasonable.
And current law allows.
If, I mean, the behavior of the parents is unreasonable. A court would have to find that the parents' behavior was unreasonable in order to get that restraint. That our request, the RFA.
And in your testimony is that in Connecticut, where this is the law, that has not been an
Could
issue.
you send us a copy of
I
that?
would be more than happy to.
Connecticut,
Yes.
response?
And I will also just say, as a rule, I mean, as a general practice, rarely are minors seeking protection orders against their parents. It's very, very rare. The vast majority of protection orders are around adult relationships.
I guess the worry is, would it become more common if the state puts tools out there that,
I guess we'll know that shortly.
Well, is there any further discussion? And Judge Zone was scheduled and I just dropped him off, and I don't know if he had any comments.
He's in the Zoom.
I want to make sure I didn't realize he was on the agenda, so.
I put it there because he had.
Do you have any comments, Judge?
No.
Okay.
That may be your shortest testimony ever.
I am aware of the discussions, and Ms. Robinson Michelle accurately represented that when they showed me this. I understand it's a policy decision to have the minors exception or not. And I do understand that if that's a policy to not have the minor exception, I do think that the unreasonable standard would effectuate the same goal. The judge would have to decide whether or not it was unreasonable. And as Michelle points out, it also brings with it the constitutional protections. And so I think it's safe to say that watching the discussion that the committee had around the table about, well, I think it might be unreasonable, or this might not be, especially in the parent-child context. I think that you're going to see that in cases, that is going to be the critical issue for judges to decide. And I would think that you're going to have differences between judges, just as you had differences across the table in your committee. And so it will be matters that we'll have to decide on the specific facts. And the statute as written does give, I think, sufficient clarity for the judges to understand the intent.
Senator Booth has moved that we report draft 1.1 favorably as, or H 27 favorably as amended and seen in draft 1.1. Is there any further discussion? Hearing none, Ben, would you please call the roll?
Senator Booth.
yes.
Senator Norris.
No.
Senator Bohowski.
Yes.
Senator Shea.
Yes.
Senator Sears.
Yes.
410.
And I.
How unusual.
Report this and Senator Norris doesn't want to. And I did the last civil issue, so I must will do this.
All right. I was gonna offer, but I'll let you do it.